In O'Sullivan v Trading 212 UK Limited, recorder Benjamin Wood, sitting in the County Court at Central London, determined costs following the dismissal of a claim arising from the closure of the claimant's share trading account in August 2021. The claim, pleaded at £37,106, but worth only a few £1,000s on proper analysis, had generated combined actual costs of approximately £700,000. The most significant costs issue was whether there was good reason under CPR 3.18 to depart from the approved costs budgets when carrying out the summary assessment. Applying Merricks v Heart of England NHS Foundation Trust and the competing approaches in RNB v LB Newham and Nash v Ministry of Defence, the recorder held that good reason to depart existed on three independent grounds. First, the defendant's solicitors' hourly rates, which exceeded even London 1 guideline rates, required reduction of between 1/4 and 1/2. Second, there had been a simplification of issues engaging the proportionality safety valve identified in Nash. Third, the trial judge's superior knowledge of the case revealed that the costs management order had been made on a fundamentally mistaken basis. The recorder assessed the defendant's recoverable costs at £113,750 for the claim generally, plus £15,000 for the strikeout application. Against this, the claimant recovered £27,000 for costs caused by the defendant's late disclosure. After set-off, the claimant was ordered to pay the defendant £96,350 within 35 days. Quote, "I have spent some time reflecting upon whether there is a good reason to depart from the approved budgets, and I have come to the conclusion that there is, both working from first principles and by parity of reasoning with each of the cost judge's decisions. Hard to reconcile though they might be, I cannot see any justification for the defendant being entitled to recover its solicitor's time at the hourly rates claimed. This was a claim that started in Hull and was case managed there, and was always of modest value. I have been able to form views about the factors set out in Rule 44.3, paragraph 5. I have formed a view about how much this case was really worth. I know that this is, and was, only a money claim. I know that this case turns on a relatively small number of documents, the application of the anti-money laundering regulations, and the interpretation of the written contract between the parties. I also know the ways in which each side has generated additional work, which cannot have been envisaged when the costs management order was made. There are no wider factors of reputation or public importance.
For a detailed summary of this decision, visit tmclegal.co.uk.